Good morning, everyone. Welcome. I'm Wendy Perdue. I'm the Dean here at the University of Richmond School of Law, and I'm delighted to welcome you to the 2016 Annual Symposium of Richmond's Journal of Law and Technology, or JOLT, as it's known. JOLT was founded in 1995, and at that time it was the first law review in the world to be entirely online. And over the next 21 years, it has remained a leader. Having difficulty hearing? It has remained a leader in the arena of law and technology. This year's symposium focuses on issues of ethics and professional responsibility as they intersect with e-discovery. It's no longer possible for a competent, ethical lawyer to simply avert her gaze from technology and hope that someone else understands it. As the model rules now explain, competence for a lawyer requires not only keeping abreast of changes in the law, but also understanding risks and benefits associated with relevant technology. This is no more important than in the area of e-discovery. And as the sanctions cases, that growing list of sanctions cases, highlight, ignorance or willful disregard of ethical obligations can be quite costly. Our JOLT editors have assembled a group of outstanding lawyers and judges with exceptional expertise on this important topic, and I think you will enjoy hearing from them and learn an enormous amount. So it is my pleasure now to welcome JOLT's annual survey and symposium editor, Eileen Waters. Eileen?
Thank you, Dean Perdue. And I would like to take the opportunity to thank all of our speakers. They've come from far and wide to be here today, so we do appreciate that. And also the rest of my journal members, without whom I wouldn't have been able to plan this event, particularly Quinn Novak and Brandon Bybee, my associate editors. And without further ado, I will introduce our first speaker, and that is Lauren Wallter, partner at Williams Mellon here in Richmond, and University of Richmond alum, actually. So, Lauren Wallter.
Good morning, everyone. As Eileen kindly introduced me, my name is Lauren Wallter. I'm a partner at Williams Mellon here in Richmond, and I chair our e-discovery and information practice group there. I'm also an alum of this law school, and I'm actually a former JOLT member as well. So it's great. It's actually very great to be back here. I think it's been about 9 years since I've been speaking at this podium, so it's very nice to be back. I'd also like to thank Dean Perdue for hospitality last evening and this morning, and Eileen Waters and the rest of the JOLT staff for their help putting on the symposium and on the, thank you. Forward and back. Awesome, thank you. For putting on the symposium and then the wonderful volume you'll receive shortly. So, now, presumably, while you're here, competence. Most professions require competence. For example, forgive me, I've been watching a lot of college basketball recently. Basketball players need to have skills to be successful. They need to be able to dribble. They need to be able to shoot. They need to know how many timeouts they have remaining. They need to know how many seconds are on the clock when they're only down by 3 and they're kind of moving the ball up a little too slowly to score that winning point. I'm obviously digressing and remembering a game from Monday night, but not only players must be able to dribble and shoot and know those things, they also kind of need to have some intangibles. They have to understand what their opponents have, what kind of skill set those opponents have, what kind of defense do they run, are they man-to-man, are they zone, or are they the pack line? And they need to know what their teammates' skills are. Is someone better in the post than others? Does someone have a better three-point than others? Does someone know when their shot is going and they're just going to take that last-minute three-point? You need to have an idea of everything around you to be the best you can be. The same is true with practicing law, and particularly when it comes to e-discovery. The model rules of professional conduct speak to competence. In fact, the comment to Rule 1.1 specifically says that competence includes keeping abreast of changes in the law and its practice, including the benefits and risks associated with relevant technologies, as you all can certainly see on the slide above. And in June of last year, the California State Bar stated that attorney competence applies to handling electronically stored information and specified at a minimum what attorneys must do to comply with that, which includes initially assess e-discovery needs, implement appropriate ESI preservation procedures, analyze and understand a client's ESI systems and their storage, the available storage they have. We'll get into that a little bit later. Advise the client on available options for collection and preservation of ESI, and identify custodians of potentially relevant electronically stored information. While the California State Bar mentioned additional competencies, the ones I mentioned implicate preservation. Preservation tends to be where judges highlight where things really went wrong. For example, failing to preserve sales software with relevant information, that may lead to sanctions. In a discrimination suit with a former employee, failing to preserve that employee's workstation or laptop, that might lead to sanctions too. So here are your reactions to preservation. You might see this a lot. The scared attorney, what? Oh no, how am I going to handle preserving relevant information and not be in a sanctions opinion? Or it can lead to this reaction. I'm a surgeon. I'm not touching e-discovery issues, especially preservation. Someone else has got to do it. I'm already scrubbed in, I'm out, not dealing with this. Another factor that leads to both of these reactions, data proliferation. Data never sleeps. Massive amounts of data is created every minute of every day. If you look at these two graphics, version 2 is here on the left, and version 3.0 is on your right. Yeah. Version 2.0 was created in April of 2014. Version 3.0 in August of 2015. There's some differences here in just that short time frame. For example, Uber, the application Uber, Reddit, not on version 2.0. I mean, think about it. I don't believe Richmond even had Uber in April 2014. So think about the proliferation of those of us that use Uber regularly. The number of tweets per minute grew between April and 2014 and August 2015. The global internet population also grew during this time frame by almost 1 billion people. And there is no reason to think these trends are going to change. Data keeps growing. You keep using it. I was just lamenting that I don't think I have enough data on my Verizon plan now that I share it with my husband, that I think we're going to go over a lot. Again, data never sleeps. So with all of this data, how do you preserve what is potentially relevant to the dispute? Do you save everything? Do you become a data hoarder? Do you have your computers and your servers look like this? It's probably not a great idea. People tend to hoard data because they can't see it. It's not like the desk or the file cabinet where you can see the massive amounts of binders or the massive amounts of papers that just continue to pile up on your desk. Much like hoarding items in your home, like obsolete clothes, toilet paper, newspapers, that hoarding data really isn't the answer to preservation. But we also have the opposite end of the spectrum, destroying or failing to retain any data, which is also not the correct answer. If we set aside for a moment the multiple statutory, regulatory, and legal requirements related to retaining documents and information, data can and does have some value for at least some period of time. Just like a piece of paper does have some value for some period of time. I mean, think about that horrible moment you have when you receive a check in the mail and you're dealing with the papers on your desk to go to recycling and your check goes away. I mean, the same is true of data. So you've got to make sure you understand what data you have and what has value. So with these views in mind, how can we as practitioners competently preserve relevant data and relevant information? For starters, we need to know when to start preserving. What triggers that duty to preserve? What the case law tells us is that the trigger is case and fact specific. But it can be also multiple things and multiple factors. It could be a preservation notice and a letter from opposing counsel saying, here's what I want, here's what needs to be preserved, and I'm putting you on notice now. It could be, you know what, I think we're gonna have to sue company X, so we need to put a preservation notice in place before we start drafting that lawsuit. Or it could be the sheriff knocking on the door, here's your complaint. But think about the different aspects now with new technologies. It could be a text message. In Clearview Technologies v. Rasnick, Magistrate Judge Graywall found that a text message sent by the plaintiff, perhaps sent after an evening of drinking, that threatened litigation triggered the duty to preserve. The text exchange included language like, keep it up or you'll find yourself in court, this is tortious interference, I'm gonna sue you. What's interesting is that the text message also included an apology, saying, to the effect of, sorry about the tweet, or sorry about the text, it was the booze. But the apology didn't say anything about reneging on the litigation. So it didn't take back that threat. So because the threat continued to stay there, Judge Graywall held that the text message triggered the duty to preserve. So as practitioners, what does this tell us? What should we be doing? When you sense this dispute, you need to start asking questions. You need to start asking, how do you communicate with people inside your organization and outside your organization? Do you communicate via text message? Do you send instant messages? How are you receiving emails about a potential dispute? For example, have you seen a presentation that outlines the lawsuit that's going to be filed against you? Because in another case from Judge Graywall, it was a presentation by Apple to Samsung, just completely outlining exactly what their lawsuit was going to be that he said triggered the duty to preserve. You can't just rest on receiving that complaint. You can't just rest on drafting the complaint. You need to think about the steps that, and this is sort of a symbiotic relationship with duty, when the trigger is and the scope of preservation, but you need to think about all the issues that sort of come to a head right before when litigation begins. So the duty to preserve has been triggered. Now what? You actually need to identify what needs to be preserved. And again, that doesn't mean preserve everything in the kitchen sink. The two cases cited on this slide reiterate that. Saving every email, every Word document, every Excel file, every piece of paper can cripple a business. Parties need to identify those documents that could be relevant to the litigation. In fact, there are many instances where documents and information are disposed of in the normal course of business, routine retention policies, and as the issues evolve, those documents may be required. As issues evolve in litigation, those documents that were routinely destroyed were then requested in litigation. AMC is a case on point. So the question becomes, was there an obligation to preserve the documents at the time they were disposed of? If the answer is no, routine disposal is okay. The touchstone is what is reasonably foreseeable to be relevant to specific, predictable, and identifiable litigation. So for example, in the AMC case, there were some documents created by an employee who was completely on the periphery of the dispute between the parties. And he left the company, and the routine retention policies, former employees only kept their data for X number of days. His data was destroyed. When the party moved for sanctions for the destruction of that data, Judge Graywall said, hey, no, once the information was requested, because this guy, looking at everything involved, because this individual was on the periphery, and yes, he created information that may have been relevant, but we didn't know that it was relevant to the litigation until further in the dispute when the documents had already been destroyed. So think about those things as you're thinking of retention policies, when you're identifying the data that's relevant. Business doesn't have to stop just because you're in litigation. I know, you can be in preservation mode for years. So just remember, routine retention policies can continue. Part and parcel with determining the scope of preservation includes identifying the key custodians with documents and information and the data sources available to those custodians and the company. It requires asking questions of both the key players in the dispute and IT personnel or someone at the company that knows the data sources available or knows what vendors have that information, to ask them questions about network servers, email servers, local workstations, mobile device policies. These questions need to be asked to determine where the data is. The case in this slide, Brown v. Tellermate, I commend you to read it because it provides an excellent outline of what practitioners need to do to competently preserve evidence. And unfortunately, it's because the practitioners in this case didn't actually do what they needed to do to competently handle ESI. This case was an age discrimination case where the plaintiffs requested reports from sales software that they had used while working at Tellermate. So they knew that this information existed somewhere at Tellermate. So they kept pursuing their counsel to request Tellermate to produce it. There were a myriad of issues with the defendant's preservation of evidence in this case, but after representations by counsel that for Tellermate that they couldn't access the data, they couldn't get to the reports, it wasn't in their control, the Tellermate, the business's corporate representative, said that anybody with a login to this particular software could access the information. Turned out that after the former employees left for their sales accounts, the company, instead of preserving the information as it was, gave the former employees login information to the new employees who were handling those sales accounts. So the data had changed. Court found that the defendants took no steps to preserve the plaintiff's data in the software application and noted that counsel for Tellermate did not ask the right questions of the right people to determine what information was relevant and therefore needed to be preserved. So what does this tell us? Ask questions. Don't just rest on an employee saying, yeah, no, I don't have anything, or yeah, no, you can't get to that because it's in somewhere else. Ask questions of IT. If your client's an individual, ask about the multiple devices that they use. Gone are the days of the very large Gateway or Dell machine that sits in the family room and it's the computer for everyone in the family. That's just not how things work these days. Ask them about their cell phones, their tablets, their desktop, and laptop, their thumb drives that they use to, say, put a presentation on and take it to JOLT for a presentation. For larger clients, identify and talk to the key players in the dispute. Ask how they use their data. Ask how they store their data. What do they use to do their job? Do they need a software application like Salesforce to do their job? Do they only store emails in their inbox? Can they create PSTs? Do they use instant messaging to do their job? Do they text message for business? Do they have a personal device that they also use for work purposes? These are all questions you have to ask to make sure you understand and get your arms around the data that is available, that is out there for you to preserve. Also, you need to talk to the IT personnel. Have them identify and describe the systems available to personnel at the company, because you will likely run into someone at the company who says, I just save it somewhere and it's there, and then I go here and I get it, and they have no idea where actually here is, whether it's on a laptop, whether it's on a network server. So IT personnel have a good idea of what is available for storage, what is available for use. Ask about file share servers, databases, backup systems. Understanding what data sources are available will help inform preservation efforts and what is reasonably accessible for preservation. For example, is a backup system completely disaster recovery, or is it a form of long-term storage? If it's just a disaster recovery system, you have a good argument in your 26F conference to say, hey, you know what, we're not preserving our backup system because it really is just for disaster recovery purposes only. And this is certainly a conversation for another day, but it'll also help inform your arguments regarding proportionality, when you're talking about discovery requests generally, and whether a request for data from certain sources is disproportionate to the needs of the current case. There was a case, U versus Japan, where a defendant newspaper company there was a preservation order in place in the case itself. And there was a certain application where it was proprietary for this particular defendant, and it was where they saved all the layouts that they were initially putting the paper together with. So it was sort of a draft layout, and they saved it for 90 days. Well, it became apparent to that defendant that this was going to be a problem, because if you save the feature of the layout of the paper for more than 90 days, it slowed the system, it had the potential to crash the system, and that really wasn't feasible for the paper. To replace it, they determined it was going to cost $18 million. Because they had all this information and because they knew that needed to be preserved, but how it was being preserved and why, they were able to go move the court for relief from that part of the preservation order, and had an agreement with the court to sort of modify it a little, to do some different searches within that application so that they didn't have to continue with that piece of the preservation order. Another thing, when you're identifying custodians, and this can come first, last, it's all kind of symbiotic, is issue a litigation hold and monitor its compliance. I'm hopeful that on all of your checklists, your litigation checklists, you already have a litigation hold right there front and center. If you don't, go ahead and add that right there at the top, issue a litigation hold. You want to issue it to those individuals that may have potentially relevant information and data, and include IT as a recipient of the hold, because they can monitor things such as turning off an auto-delete function or monitoring who has access to what network file here and there. Monitor compliance with the litigation hold. Monitor what the recipients of the hold are doing to comply with the hold. I mean, sending out the litigation hold and then sort of going back to the surgeon and not doing anything, that's not going to work for just a number of different reasons. As I mentioned, you could be in a hold status for years. And quite frankly, just like with anything else, you do something for long enough, you kind of get fatigued. So it's preservation fatigue. That's not okay. If you're under a hold, you've got to continue to preserve that information. Monitor, are the auto-delete functions still off? Hey, have new employees joined the company that need to be notified of this hold? Monitor these steps. Monitor the scope of the hold. As most of you all know, during a litigation, the issues kind of change and move around, and what was not even mentioned when you sent out the hold is now the hot spot of the litigation, what everyone is fighting about. So make sure that your litigation hold is refreshed and encompasses new issues as they arise. So now I've given some do's for preservation. But taken together, what do all these steps mean? Judge Francis, later this afternoon, is going to talk about Rule 37E a little bit more. But these all can have application in the amended Rule 37E, which is the new sanctions component. From a preservation perspective, Rule 37E is interesting. 37E now permits sanctions for destroyed evidence only where a party fails to take reasonable steps to preserve the evidence and the evidence is lost. So now, if you can show that you've taken reasonable steps, you at least have an argument to say, hey, we shouldn't be sanctioned. We don't deserve a default judgment. We don't deserve adverse sanctions. So again, anytime something can provide an argument, use it, take it. So how do you make the argument that reasonable steps were taken? Show your work. Algebra teachers across the nation have said it for years. I can still remember mine saying that to me. Show your work. Document the processes and steps taken to preserve potentially relevant evidence. Issue a litigation hold. Monitor its compliance. Revise it as necessary. Identify and interview the key players in your litigation regarding their ESI, how they use it, what they use, where they store it. Have they heard of a thing called a computer? Ask them about these things. Interview IT personnel regarding the data sources available to their client. Again, clients may not know where they're saving data. Ask them about network shares. Ask them about software applications, databases. Do employees have the ability to save locally on a laptop? Document which devices were identified as having potentially relevant information and how that device was preserved. Is there an employee who both uses a business phone and a personal phone to conduct business? These things should be documented. These things should be preserved. Where necessary, disable auto-delete functions. And if you've got a big corporation, a big client, there's also software out there that can help with preservation. So think about looking into those things as well. Analyze retention policies that you're using and you're actually using. You want to look at the categories of information that you need to preserve and then that you're required that you're legally obligated to preserve, and ensure the routine destruction for those particular documents has stopped. If there are no other obligations for you to legally, statutorily, regulatory, any reason to preserve, you can continue to use the policy, but make sure you know what bucket, what document goes in. So, again, when thinking about preservation, show your work. Taking these steps and documenting these steps hopefully will help you demonstrate to a court that you don't need to be in a sanctions opinion. Thank you.